Hello class, and welcome to your Chapter 11 lecture, where we're going to be discussing prisoner reentry, specifically looking at collateral consequences, parole, and mandatory release. So the learning objectives for this lesson are that by the end, you should be able to examine the preparations that are needed for reentry while an offender is still incarcerated, discuss how collateral consequences affect the reentry process, describe examples of civil rights that are lost as a result of a felony conviction, explain the discretionary parole process of how prisoners become eligible for release, as well as to describe a typical parole board hearing, including the legal issues in parole board decisions. So let's first begin by discussing some challenges that re-entering offenders are presented with. So first is a lack of mentoring or resources within the communities and a lack of opportunities within the communities, whether that's employment, housing, support. They typically have no concrete plan unless they're involved in a reentry program while they're still incarcerated. So they come out not knowing how they're going to make money, where they're going to be living. They then have the financial issues because they have not been able to hold a job, or if they did hold a job while they were incarcerated, they typically do not make very much an hour, and that money was mostly going towards their fines, fees, and costs. They also tend to feel rejected by society and oftentimes are rejected by society. And then we have to look at the gender differences. So females specifically tend to report feeling more isolated or lonely, and they lack family support more so than males. So what are some further issues we have in reentry? So let's look at the fact that 95% of incarcerated prisoners will eventually return to their communities. 80% will be via discretionary or mandatory release, which means that those offenders will be under some type of supervision, while 20% will be released after they've served their full sentence. So they will not have any type of supervision after release. And this also means that they're being released possibly without any resources because they're being released outright. So reentry then aims to integrate parolees back into their society. So they'll help by making appointments for the offenders before they leave, because some offenders don't even know how to make appointments for themselves. Looking at female parolees, they have some additional concerns. They may need some help filing PFAs or protection from abuse orders from abusive relationships. They may need help advocating to get their children back, or even help with the family reunification process. So oftentimes, these offenders will additionally have just daily life challenges. So how do they obtain a bus pass? How do they get an identification, a state identification card, which is typically needed to apply for anything you want in life, as well as similar to housing and employment? And then even just the daily challenges of maintaining sobriety. So when you are being released out from prison, you have all of these stressors, all of these issues pressing down on you, and you're struggling. So even those offenders who maybe didn't struggle with substances or alcohol before may turn to that simply because they're so stressed. And sometimes offenders will even minimize their crimes to employers or fabricate a new crime to the employer so that it doesn't sound as bad. However, the issue with this is that it presents as the offender is still being manipulative, and it can create distrust. So this is one of those pieces that we would hopefully help with in the reentry process, even while the offender is incarcerated, is in that reentry process explaining to them how important honesty is. So collateral consequences for a felony conviction are long-term consequences to their reputation. So they will also lose some civil rights for different offenses. So one of the reasons for removing civil rights from offenders, the first one is that we want to make sure that the public can be confident in the courts and in our government. So this is why they argue why some offenders with certain offenses are not able to hold a public office. They may lose their voting rights, and they may not be able to be called as a credible witness in future testimony or hearings. Another reason is that they argue tax benefits are for law-abiding citizens. So those who break the law in areas of public welfare, pensions, or student financial aid should not have access to certain benefits because they've been dishonest. And then a final reason is that these consequences increase public safety. So for example, protecting children in the community from harm through things such as the sex offender registration or firearm restrictions for certain felony offenders. Now, finding employment can be very difficult, as we know, for a returning parolee. So we have 6 different issues that can present while an offender is trying to find employment. So the first one we want to look at is the application process. So while blanket bans are no longer allowed to be used, which means that you can't turn an applicant away solely based on the existence of a criminal record, applications can ask, which is very common, if the offender does have a felony conviction. In about 50% of applications, they will also ask about misdemeanor convictions. And some even ask about any prior arrests or pending charges. So meaning that the offender did not even have to be found guilty of anything, but just have they been arrested before. When we look at background checks, some states only allow the background check to be run after a conditional offer of employment is made. So that way, they're basing it on the individual's skills and their resume rather than first looking at their background check. And then surety bonds are actually required for certain types of employment. So for individuals, for example, who work at banks, some truck drivers, and collection agencies, they'll actually require the employee to be bonded. So in this way, the surety bond is going to be signed by the employee and then typically by a third party like an insurance company that promises to pay the employer back in the event that the employee is dishonest. However, individuals who have a felony conviction can be denied a surety bond, which then prevents them from holding positions in these types of employment areas. So the Equal Employment Opportunity Commission policy actually says that criminal records can be used in hiring decisions. However, employers cannot use a blanket exclusion on all felony offenders. For example, the felony conviction must have a direct relationship to the position that's being sought in order for the employer to deny that offender the position based on their felony conviction. And then if we look at the Criminal Offender Record Information Report, so in some states, this report is actually required to be presented to the employee or the employment candidate with written reasoning for why that employer is denying the hiring of that candidate. And then the candidate has the opportunity to refute any inaccuracies that were presented on that CORI report. And this is very important because we want to make sure that if an offender is in fact being denied employment based on prior convictions, that the employer needs to explicitly state that and that the employee has an opportunity to refute anything that may be incorrect on that report, because we're not perfect. Data entry is not perfect, and it's possible that it could say something inaccurate on that report. And lastly, we look at ban the box legislation, which simply limits what employers may ask on an application. So looking at other rights that these felony offenders will lose. So they can lose the right to vote. So in Richardson v. Ramirez, the Supreme Court held that it is constitutional for states to deprive ex-offenders the right to vote. The problem with this is that African American men are disenfranchised at rates 7 times the national average, according to the Sentencing Project, which is a direct result of institutionalized racism. They may also lose their right to own or possess a firearm, to receive government benefits, and this is typically with drug offenders. Similarly, with drug offenders, they may be denied higher education financial aid. So now we're not only preventing these individuals from obtaining jobs, but we're blocking their opportunities to receive financial aid so that they can increase their education and potentially receive a better paying job. For drug and sex offenders, there can be the denial of welfare or even public housing. So sex offenders who must register for life, who are lifetime registries, and offenders who have manufactured methamphetamines on public housing property are banned for life from public housing. You can see the issues this would present in these offenders attempting to secure appropriate housing upon reentry. And drug offenders, all drug offenders, can be banned for 3 years from public housing. Additionally, some states allow for the termination of parental rights simply for having a felony conviction. It does not matter what that felony conviction was for, just that it's a felony conviction. And then offenders can even lose rights in court. For example, they may not be able to serve on a jury, and they may not be able to be called as a credible witness. And for those offenders who are convicted of perjury, there is absolute disqualification in these areas. So looking at the reentry process, what are the different ways that offenders can be released? So we've talked about this in a prior chapter, but it's good review. So we look at minimum eligibility date, maximum eligibility date, and then how good time plays into that. So the minimum eligibility date is the shortest amount of time that an offender serves before they may go before the parole board. The maximum eligibility date is then the longest time that the offender serves before they must be released mandatory. So they must be released at that point. Good time plays into this because it offers a sentence reduction for good conduct. And as always, it helps reduce prison overcrowding, which we know is a major issue. However, an offender can lose good time for poor behavior. It's typically automatically granted, and offenders can earn roughly between 4 and 45 days per month off of their sentence just for behaving. So let's look at the eligibility date for parole. So in mandatory minimum states, those using mandatory minimums, the offender will typically serve between 50 and 85% of their sentence before they're eligible for parole. In discretionary parole states, the offender must serve 1/3 of their sentence before being eligible for parole. In the federal system, a minimum of 1 year mandatory parole is required for offenders who have served 2/3 of a 5 or more year term, unless that offender has had serious disciplinary infractions in prison, or there's been determined that there's a high probability that that offender could recidivate, then they can be given longer on parole. So how do we prepare offenders for release? So we have pre-release facilities and pre-release plans. So pre-release facilities are actually minimum security programs that will house inmates who have earned a lot of good time, who have behaved while they were in prison, and who are typically within about 2 years of release, to help them reintegrate back into society, to help prepare them for this reentry process. So they'll use pre-release plans, which are simply a summary of their institutional conduct, as well as what programs they've participated in, and then it provides a plan for where that offender is going to live, where they're going to be working once they're released. And by doing this, we actually increase the offender's chances of obtaining parole. It saves time during parole hearings because everything is already laid out for the parole board. And it reflects that the offender has ties in the community, or if they have ties in the community, that will assist in their reentry. So do they plan on going to church? Do they plan on being involved in any nonprofit organizations or getting involved in their communities? Do they have family in the community? Are they going to live with a family member that supports them? Do they maybe have a family themselves, a husband, a wife, children that are going to be there to support them? This pre-release plan explains all of that for the parole board, so it's already set for them. Similarly, We use reentry risk assessments just as we do for those that are being placed on community supervision. So those who are given probation in lieu of incarceration and now offenders who are being placed on parole, we use risk assessments. So these reentry decisions by the parole board will be made based on information such as the offender's age, how serious their offense was, and then looking also at prior institutional commitments. So have they been in jail before? Have they been in prison before? So we also need to look at the releasing authority, or what is a releasing authority. It's basically a parole board, but know that prison releasing authorities are parole boards. It's the same thing. But this is a group of individuals who have the authority to release a prisoner prior to their sentence being completed. So that's all it means. It means that the offender did not have to serve their full sentence, and that this releasing authority has been granted the authority to allow this offender out of prison prior to them completing their whole sentence. So traditionally they've been known as parole boards. Today they've been called a number of other things, but parole board is what we're going to use for our purposes in this class. So what are the functions of our parole board? Well, they average about 7 members, and they can be appointed by either the governor or head of the Department of Corrections. They will typically serve a 5-year term. And parole boards have 4 basic functions. They can decide when prisoners should be released. They will determine any special conditions for that offender while they're on parole supervision. They will successfully discharge the parolee once those conditions have been met. And then they can also determine whether the parole privileges should be revoked if the offender violates those conditions that were set in place. So they also have a few other additional functions. So they can at times grant furloughs, make executive clemency decisions, restore civil rights for offenders that were lost that we discussed previously in this chapter. And they can also grant reprieves in death penalty cases. But know the 4 main basic functions of parole boards. That's going to be helpful for you. So what happens in a parole hearing then? They're typically tape recorded, conducted either in person, which is ideal, although they can be conducted through video teleconference, or via a hard copy paper file, which is where they're simply given the offender's file and it's hard copy paper, and they review it that way without anyone being present. So in a parole hearing, the goal is to resolve any inconsistencies that were presented in that offender's pre-release plan, to review institutional program participation, as well as their conduct within those programs. So not only did they present in those programs, but were they cooperative? Did they really engage in the treatment? They'll consider the inmate's own internal motivation to be placed on parole, and consider input from the victim and any other interested parties. So speaking of interested parties, let's find out who can attend a parole hearing. So states will vary a bit on who can attend these hearings. However, most of them do not permit legal representation to be present. Although law enforcement, prosecutors, and victims who are directly related to that case are usually permitted to make a statement. So for example, say it's a very serious offense, a very serious case, and you had a law enforcement officer who dedicated many hours and much time to this case. It's possible that they will present at that parole hearing to give just additional information to the parole board so that they understand the gravity of the offense more so than what they could have possibly read on paper. Same with the victims. So usually a victim impact statement will be written. Sometimes it can be verbal, and it will describe the crime's physical, emotional, financial, and psychological impact on either the victim and or the victim's family. So if the victim is deceased, the family may also write a victim impact statement describing how that victim's death has affected the family. And then additionally, you can have relatives and even potential employers submit written or sometimes videotaped statements to the parole board for them to consider. So again, it's this whole idea of making sure that we're making an individualized decision and not simply just looking at what's presented on paper or the facts. Let's get a little bit of additional, maybe subjective information to make an appropriate decision on this offender. So parole boards have to consider a number of things in making a decision on whether or not to release an offender. So they're going to look at how severe was the crime and what type of crime was it? What does the offender's prior criminal history look like? What did the victim have to say about it? Is the victim comfortable with the offender being released? Sometimes parole boards have nearly released an offender, but solely based on victim impact testimony have denied parole based on that. So it is definitely taken into consideration, and it's weighed heavily in parole hearings. Most parole hearings. Let's look at the probability of recidivism for that offender. Input from the offender's family and the district attorney. What risk does this offender present to community safety? How did the offender behave while they were incarcerated? And how sufficient is this release plan? Does the offender have enough resources? Does the offender have an appropriate plan in place so that they can be successful once released? So what are the options that a parole board can make? There are 3 decisions that can be made at a parole board hearing. You can either grant parole, be denied parole, or defer the release decision. So if granted, they'll be given a conditional release. So they'll be given conditions they must abide by, similar to community supervision or probation supervision. If they're denied parole, they will continue to be imprisoned. If they decide that they need to defer release of that offender, this just delays the granting or denial decision, and it's typically by 6 months to 1 year. The difference, however, is in the federal system. So if the offender is given a sentence of greater than 7 years, the offender will automatically go before the parole board after 18 months. However, if they're given a sentence of less than 7 years, the offender must wait 2 years before going before the parole board. So many release decisions are actually made by just a panel of the entire board rather than the entire board. So you may have 3, 4, or 5 members rather than all 7. Although violent crimes and those that are sexual in nature will often require a full board review. So you do have to have the decisions of all 7 members. When deferring parole, there are typically 2 reasons why that happens. So it's typically because of either an administrative delay, they just don't have the paperwork or the information that they need, or the offender has not completed treatment. But this issue is typically more related to space availability in treatment programs rather than the offender's willingness. So they may tell the offender, look, go back, get into this program, complete the program, and then you can reapply for parole. So let's cover some legal issues in parole hearings. Let's look at due process first. So in the case of Menachino v. Oswald, the Supreme Court ruled that parole itself is a privilege and not a right. And then in Greenholz, the Supreme Court established minimal due process protections in the parole granting process. So this case said that the parolee must be given reasonable notice of the parole hearing date. There must be a hearing conducted where the prisoner can present evidence in favor of their case. And when parole is denied, the offender must be given written reasons why. Hearsay is able to be used in parole release decisions according to Goldberg v. Baylor. However, parole cannot be denied for either false, insufficient, or capricious reasons. So when the parole board is denying an offender parole and they're giving that written statement of why and written reasons why, it cannot be for any of these reasons above. And this one is interesting. So DNA evidence for a crime that the offender has not been prosecuted for has been used to deny an offender release. There's nothing that says this cannot happen. So for example, for certain offenses, offenders must give their DNA. They have to submit to DNA analysis. This is even for juveniles. It applies to both adult and juvenile equally. That DNA, say it was tested against another crime and it was found to match. However, they never decided to prosecute that offender for that crime simply because the DNA matched that evidence for the other crime. Parole boards have been able to use that to deny the offender release. You tell me whether you think that is legal or not, or should be a valid reason to deny release of an offender. And then let's look at attorney presence. So prisoners who are seeking parole, again, do not have the right to be represented by counsel. However, a lawyer may attend to support the prisoner. They're just not able to speak during that parole hearing. Additionally, parole board decisions are not subject to judicial review, so long as they are made in line with the statutory guidelines. So I know we've covered this before, but so long as that decision was made in line with the guidelines in the statute, a parolee cannot then ask for a judicial review of that parole decision. And finally, we make it to community-based reentry initiatives. So what are some initiatives that we currently have to help our offenders reenter society that are community-based? So these reentry initiatives have grown to support not only housing, job placement, but also mentoring services and faith-based initiatives. So for example, the Federal Interagency Reentry Council was established by former President Barack Obama, and this actually established a school district within the Bureau of Prisons so that every offender was able to finish their high school education. Looking at workforce development, there's a program called STEP, or the Solution to Employment Problems, which actually is a manufacturing business initiative which will provide jobs to offenders. So they provide equipment and training to offenders while they're incarcerated, and then guarantees them a job upon release, so long as they prove themselves to be a valuable employee. This has actually been shown to improve employment rates and reduce recidivism. Now, I've said it 100 times and I'll say it 100 more. Employment is the number one positive pro-social activity that we want offenders to engage in to help reduce recidivism. So these workforce development programs will provide services to the offender. They may help them search for jobs, help them write a resume, even practice interviewing skills. It's hard enough for me to interview. I can't imagine an offender who hasn't held many, if any, jobs coming out into society and sitting in front of someone and being able to confidently answer questions. They may also educate employers on tax breaks that are given or incentives they have for hiring ex-offenders. So there are initiatives out there that will give employers tax breaks or even incentivize them to hire these ex-offenders. Now, reentry courts, they're similar to the other types of courts we've discussed throughout this course. So they're collaborative, team-based programs that aim to improve the link between parole supervision and the treatment providers. So through contracts between parole and then the treatment providers, and by using a structured court hearing, we hopefully can ensure that the offender is going to participate with whatever that identified program is, whether that's based on housing, job training, substance abuse treatment. Though it is important to note that your text states that there was a recent study which showed that judge-led problem-solving courts actually had higher revocation and rearrest rates compared to those that were placed on traditional supervision. It's just something to note. And then I know we've covered kind of day reporting and electronic monitoring, but we want to discuss this particularly in the context of parolees. So typically a parolee in a day reporting center will spend about 6 months after they're released. Day reporting centers will also give them substance abuse counseling, anger management. There's cognitive behavioral approaches that are very important to changing not only the cognition, the way the offender thinks, but also their behavior, the way they then act, and the way those two interact with one another, as well as employment assistance classes. When we look at electronic monitoring, there's GPS. Typically, a parolee will spend about 6 to 12 months on average on electronic monitoring post-release. So how effective are all of these reentry initiatives and programs? How effective are the different types of parole? So when we look at parole and mandatory supervision, discretionary parolees do tend to be more successful than mandatory release parolees for very obvious reasons. Discretionary parole is based on how that offender did, looking at their behavior, their desire to be on parole, how they've done in programs within the prison, whereas mandatory release is because the offender's time is up and we need to get them out on parole. So they may not be truly as ready as someone who was released on discretionary parole. So discretionary parole does have the lowest recidivism rates in the short term, though overall, parole does not have long-term rehabilitative effects. And by that, we're simply looking at just parole. Parole itself, placing an individual on parole, does not have long-term rehabilitative effects. We need to give them reentry programs and treatment. So reentry programs are effective at reducing recidivism. Especially when these services are directed at individual change, they will have greater effects than those that are directed at practical needs. So when we're looking at addressing substance abuse, mental health, they're going to have greater effects than when we're simply just looking at let's find the offender housing and let's find them a job. Additionally, we will see the longest term recidivism reductions when we address those root causes of behavior. In sum, reentry programs include prison settings as well as those based in the community. Parolees will face many issues, including housing, employment, and even reestablishing contact with their family. Some collateral consequences can be either civil disabilities or the deprivation of civil and political rights. There are 3 types of ways an offender can be released from prison. We have outright, those placed on mandatory supervision, and then discretionary parole. Parole boards can release offenders under discretionary parole and even determine revocation in certain cases. Reentry initiatives do include reentry courts and collaboration between justice agencies, community organizations, and parole agencies. Parolees who are on active supervision will have lower recidivism rates than those who have been released from supervision because they're now lacking the supports that those who are on active supervision have. And finally, reentry services that emphasize changing the cognitive thinking, that increase education, as well as address mental health and drug treatment, will have longer and greater recidivism reductions for offenders. So that was your Chapter 11 lecture on parole and reentry. I hope you all have a wonderful week.